Respected Shri Vinod Singh Rawat, Director JTRI, esteemed Speaker of the Day, Shri Manish Mehrotra Advocate, High Court at Lucknow, and Shri Samir Shah Advocate, High Court, Lucknow. Ahmedabad. Sorry, he's in Ahmedabad. Advocate, High Court, Ahmedabad. Respected presiding officers of commercial courts and respected district judges and all other respected participants. Good evening to you all, and I welcome you all in this 2 days program on expeditious disposal of matters relating to commercial courts and arbitration in Lok Adalat. The forthcoming Lok Adalat will be the focus of this. Mr. Manish Mehrotra, the main speaker of this evening, is well known to almost the entire UP judiciary because he has already addressed many gatherings, including respected district judges and respected commercial court presiding officers on arbitration and commercial court matters. He is a practicing advocate with a wide range of experience in the field of study that we have taken. The purpose, as we all understand, is to fetch maximum number of disposals in the forthcoming Lok Adalat. How to do it, what mechanisms could be adopted, the way in which we could focus on this will be the areas to be covered, in which the respected participants have themselves a very rich experience. Let me slightly introduce Mr. Samir Shah, because he'll be joining in between and getting involved in discussion. So we'll not have time for his introduction. Mr. Samir Shah is an advocate dealing in international arbitration, and he is an international arbitrator, mediator with an active legal practice of 27 years. Director, Chartered Institute of Arbitrators, London. Founding trustee, ADBR Bar. Co-founder and executive committee member, energy-related arbitration practitioner, India chapter, because he deals in international arbitration as well as Indian arbitration. He is a member of advisory board in Gujarat International Maritime Arbitration Center. He is a panel arbitrator on Court of Arbitration for ART, Netherlands. He is a faculty trainer, mediator, IM Campus, Germany. Founder and proprietor of SU Shah and Associates, Ahmedabad, India. He is member National Committee for Legal Services, Confederation of Indian Industries. So the other distinguished speaker of the evening is also a very experienced scholar in the field of arbitration, particularly the international arbitration. And his rich experience in the field, I believe, will be very useful, interesting, enjoyable, and will be a great addition to this evening after a tiring day with the judicial work. So without wasting any more time, I would now request Shri Manish Mehrotra to initiate the discussion this evening, and then it will be advanced and joined by Mr. Shah, and then there will be a discussion with the participants. Over to you, Mr.
Thank you, Answer. Thank you, Director Sir, for being with us this evening. First of all, a very, very good evening to all of you. Today, I've interacted with everybody on various aspects of arbitration law. So today we are treading on a new path, and my opening remark would be that when you tread on a new path, especially in context of commercial litigation and arbitration law, you have to tread with caution. So I would very proudly say that Allahabad High Court and the judicial setup of Uttar Pradesh has been always a leader and a pioneer in so many aspects of the development and the march of law. And this concept of bringing into the fold of Lok Adalats, how maximum benefit can be taken for expeditious disposal in commercial matters and in arbitration matters also, is a new challenge which is before all of us who are students of law. And as I had last time said, that when I come and speak to all of you, it is not only that I am interacting, but I myself find myself as a student, and I have learned so many good things from all of you experienced judges by the various questions and the interaction which we have. I would today request everybody that let this be a kind of an interactive session, because there may be brainstorming is a must. I am not saying that for every question I will be always ready with an answer. I am also in the process of learning, but then with little bit of experience which I have, particularly in resolution of the disputes by arbitration, I'm sure that I will also be in a position to assist you all with some kind of a roadmap that how and what our state should do for expeditious disposal of the matters through the process of Lok Adalat. Now, when we think in, I'm just introducing this topic, and of course, Samir ji, actually last time जो बैकअप है ना, इसको चार्ज रखा एक बार ये और यूपीएस जो है ना, ये चार्ज नहीं है।
क्या मुसीबत है यार। कुशल बल साहब का है। अभी दोबारा स्टार्ट होगा वो सब।
हाँ, वो जनरेटर चलेगा, लेकिन ये वाला जो यूपीएस
कई बार मैं इनको कह चुका हूँ, क्या मैं
सर ये नया मंगा लीजिए।
सर यहाँ पे आपको पता ही है ना,
हाँ हाँ मैं समझ गया,
कितनी चीजों पे मैं सर खपाऊँ।
सही बात।
आपकी आवाज सर क्लियर आ रही है और आप दिख भी रहे हैं, हम लोग चालू रख सकते हैं बातचीत सर।
ये सुनिए, आवाज आ रही है
सर आप
बिल्कुल क्लियर आ रही है।
ओके, अरे वाह, वेरी नाइस, थैंक यू सो मच। So only the visual is gone. So now was, as I was saying, when we think in terms of the whole concept of chances of the result which we can get into by Lok Adalats in the matters, commercial disputes and arbitration matters, there are 4 acts which come to my mind, which all of us have to see and refer. One, of course, is the Code of Civil Procedure. Then there is the Commercial Courts Act. Then there is the Arbitration Act. And then there is the Legal Services Authority Act. And I'm sure that all of you know that the first Lok Adalat was held in the year 1982, when Honorable Mr. Justice Bhagwati, who was the founding father of this concept of Lok Adalat, held the first Lok Adalat in Gujarat, in the state of Gujarat. Then the next one was held in Kolkata in 1986, and 1987, the Legal Services Authority Act came into force. So statutory recognition was granted to Lok Adalats in the form of the Legal Services Authority Act. 1999 again, according to me, was a very benchmark year insofar as ADR is concerned, because Lok Adalat is one of the limbs of ADR, and section 89 of the CPC I want to refer, and I would I'm actually just emphasizing on one aspect of section 89, where the language will give us a sense of direction that how we have to go about and what actually can be considered in commercial matters insofar as Lok Adalats are concerned. Now, if you go through the language of section 89, you will find that 2 words in the initial opening portion of section 89 subsection 1, where it appears to the court that there exists element of a settlement. So therefore, where it appears to the court that there exists elements of a settlement, so which may be acceptable to the parties. So two basic phenomena which originate insofar as the concept of ADR, because section 89 postulates 4 mechanisms by which the matter can be actually sorted out without getting involved into endless litigative process. One is the arbitration, then Lok Adalat, thereafter mediation, and judicial settlement. These are the 4 aspects. So the test is that the willingness of the party to actually opt for settlement is one of the key kernel factors. And even while the stage of referring the matter to Lok Adalat is concerned, as I said earlier when I started, that we are treading on a new path. Lok Adalat has been extremely successful in various areas of litigation. But here, we are specifically dealing with special laws. Now, if I will just like to refresh that both Commercial Courts Act and the Arbitration and Conciliation Act are special laws, which the foundation of that, if you read the statements of objects, aims and objects, either of the Commercial Court Act or of the Arbitration Act, the whole benchmark is expeditious disposal, quick justice. That is the essence. So here we are dealing with 2 statutes in referring those matters to Lok Adalat, which are already in place for expeditious and early disposal. So it needs a special handling. So it is not every and all kinds of litigation which actually, according to me, can go into Lok Adalat. Some kind of the principle of law of harmonious construction will have to be done, where this is a very interesting initiative which has been taken by the judiciary of the Uttar Pradesh, that we can use the good offices of the Lok Adalat to get the matter resolved between the parties, iron out the creases. Because now let us come in context to Arbitration Act. Now there are 2 situations in which the commercial courts would be dealing with, all the courts dealing with commercial matters under the Commercial Courts Act would be dealing with the arbitration, which do stand a chance of some expeditious disposal through the process of Lok Adalat. One is section 34, when the award is challenged between the parties, and there is a direct judgment of the Honorable Apex Court of India that even at the stage of section 34, the parties can settle and the matter is actually disposed of as a consent decree. So I would request you that kindly note down the citation of this judgment, which will be very handy for all of you. 2015, volume 5 SCC. I repeat, 2015, volume 5 SCC, page 747. And the party's name is Y. Sli Bachen, SLEEBACHEN versus Superintending Engineer. So this judgment and the relevant paragraphs are paragraphs 7, 15, 18. I repeat, paragraphs 7, 15, 18, 20, 21, and 23. So these 5 paragraphs will very hurriedly give you a gist that how section 34 stage also the matter can be settled. And the willingness of the parties again is the catchword. Now, if we talk in terms of section of the Arbitration Act, I am coming now to the principle of Commercial Courts Act in 2 minutes. Section 30 of the Arbitration and Conciliation Act provides that at any stage of the litigation, the arbitral tribunal shall make all efforts to
disconnect. इसको इस पोजीशन पे रखना है कि हमारी आवाज नहीं जानी चाहिए।
बोल रहे हैं ये कौन सा नंबर है?
ये है ऊपर से 18 है, नीचे 17।
हमारे यहाँ को नहीं है प्रॉब्लम, सबके एक्सप्रेशन बता रहे हैं कि किसी ने खुली से बता क्या है कुछ तो नहीं ये अनाउंस कर यहाँ पे
इसका फीड नाम क्या होगा ना कौन फीड कर रही थी
तो बारे में है तो वो अपना कैमरा बंद कर रहे थे, वो सुन रहे
ओके
कनेक्टेड है लेकिन कैमरा ऑन नहीं करेंगे वो बढ़िया
पास ये एक नाम करेंगे और कोई नहीं सकते हैं कैसे
Can you hear me now? So this is what I'm coming back to it. So therefore, there will be a lot of trivial matters, small matters, which the parties will more than be happy to get the matter finalized at the stage of through the process of Lok Adalat. Now, when this topic came up, the first question which came to my mind was that whether in the real sense, the matters under the for Lok Adalat of commercial disputes and commercial nature and of arbitrations are actually referable to the Lok Adalat. Well, the answer, logical answer which comes that if there is, if supposing there is no real advantage, then there is neither any real disadvantage. Because as the record suggests that last time when the Lok Adalat was held, in particularly in context of section 36, as per the figures which have been given to me, a substantial number of matters were referred to Lok Adalat, but then there were a disposal of about 2,000-3,000 cases. So at least to that extent, it is a definite advantage, and it will, I'm sure, catch up very soon insofar as this is concerned as a kind of a movement. Now, one more. Now let us come to the Commercial Courts Act. Now, Section 12 capital A talks of pre-litigation mediation. Now, that is, according to me, also another provision which reflects upon the intention of the legislature, and then a very recent judgment of the Honorable Apex Court of India, which I am just going to refer, because this is the purpose of our meeting today. Because in the, kindly note down the latest judgment on this Section 12 capital A of the Commercial Courts Act. The citation, this is Messrs Patil Automations, Messrs Patil Automations Private Limited versus Rakheja Engineers. Messrs Patil Automations Private Limited versus Rakheja Engineers, 2022 SCC Online. 2022 SCC Online, Supreme Court, page 1208. 2022 SCC Online 1208. Now, there are two very important concepts which I want to emphasize and share with all of you. In paragraph 57, of course, this is this pre-mediation litigation insofar as Section 12 capital A is concerned. In this case, the Honorable Apex Court says that it is a mandatory provision. So here was a case where a litigation arose and there was an objection that this petition, on the principles of CPC, that this petition on the face of it is not to be tried by the commercial court concerned, because the pre-mediation exercise has not been done. So it is not maintainable. The court below said that no, it accepted, rejected. The Honorable High Court said that no, it is a directory provision, and on this ground alone, to defeat the suit would not be a good exercise. So they overturned the decision, and the Honorable Apex Court ultimately upheld the trial court. But in that exercise, the whole checkered history of litigation on directory and mandatory interpretation of the provisions has been given. But two sentences the Honorable Apex Court uses, and I say that precisely because of that, today you and me are interacting here. The Honorable Apex Court says a new approach is needed. A clean break from the past is needed. Now, so these are the two things which actually attracted me a lot to this judgment. And it is in a spirit with the efforts, sensitizing programs, the interactive sessions which all of us are having over here, that we need a new approach and a clean break from the past. So the new approach and clean break, and as I said again, that since we are treading a new path, we have to tread with caution. But this is a mechanism that where on a case-to-case basis, looking to the willingness of the parties, which is always the consistent mandate, because the root provision, according to me, in this regard of ADR, also including Lok Adalat, is Section 89, which says that where the court sees that there is a chance, then obviously through the process of Lok Adalat, this matter can always be resolved. So these are some of the aspects which I wanted to share. तो अब हम लोगों को जो बेसिक चीजें अगर मैं समराइज करना चाहूं, क्योंकि इसके बाद समीर शाह साहब से, क्योंकि लोक अदालत भी एक तरह की मीडिएशन की एक्सरसाइज है और मेरी भेंट कुछ महीनों पहले समीर शाह साहब से हुई, इसीलिए आज मैंने JTRI वालों से भी अनुरोध किया कि आपको भी आमंत्रित करके और हम लोग को इनके नॉलेज और एक्सपीरियंस का कुछ फायदा मिले। तो जो ओपनिंग मेरा एक कमेंट है वो ये है कि हमें एक नई अप्रोच के साथ है, ऐसा नहीं है कि कमर्शियल डिस्प्यूट्स और आर्बिट्रेशन मैटर्स में लोक अदालत फीजिबल नहीं है। ये जो 2 जजमेंट्स मैंने आपसे शेयर किए हैं, रेड विद सेक्शन 89 then section 12 capital A of the Commercial Courts Act, all taken together, the possibility is there, but this concept has to grow. We have to, हमें एक बहुत गार्डेड ढंग से इसमें कदम रखना है। हम किसी को भी, क्योंकि देखिए 1 मिनट के लिए जो मैटर रिजॉल्व होते भी हैं लोक अदालत में, तो वो कल्मिनेट करती है कंसेंट डिक्री के फॉर्म। तो जब तक पार्टी की रजामंदी नहीं होगी तब तक ये कह देना कि हम लोक अदालत से डिस्पोजल, मेरा पॉइंट ये है कि लीगली पॉसिबल ही नहीं है, वो हो ही नहीं सकता। लोक अदालत में रिजल्ट तभी निकलेगा जब दोनों पार्टी सहमति देंगे और कहेंगे कि हाँ सर, इस मैटर को हम यहाँ खत्म करना चाहते हैं। तो हो सकता है कि आज की तारीख में हम 50,000, 1 लाख या वॉटेवर 10,000, 5,000 कुछ भी लिटिगेशन छोटे मोटे हम आइडेंटिफाई करते हैं कि एग्जीक्यूशन पेंडिंग है। सेक्शन 34 में भी हो सकता है पार्टीज आके चाहें कि छोटे छोटे मैटर, खास तौर से जो आप लोगों के समक्ष हायर परचेज एग्रीमेंट, जो गाड़ियों के लोन के संबंध में मैटर्स आते हैं या एमएसएमई के मैटर्स आते हैं। बहुत देखिए, एमएसएमई भी एक बहुत इंपॉर्टेंट एस्पेक्ट है। आई एम श्योर कि समीर शाह साहब उसको भी टच करेंगे कि एमएसएमई के भी जो मैटर्स आते हैं, तो सारा एक्ट ही इसीलिए बना है कि भाई हमें स्मॉल और मीडियम स्केल इंडस्ट्रीज को प्रोटेक्ट करना है। और फिर वो आर्बिट्रेशन में आता है मैटर, स्टैट्यूटरी आर्बिट्रेशन है, फिर अल्टीमेटली हमारे पास उसी प्रोसीजर से सेक्शन 34 में कमर्शियल कोर्ट्स में भी पहुंचता है। तो बहुत सारे एवेन्यूज हैं जहां पे हम सेक्शन 89 आर्बिट्रेशन एक्ट का जो स्पेशल एक्ट है उसका ऑब्जेक्ट, कमर्शियल कोर्ट एक्ट जो एक स्पेशल एक्ट है, ये जो ऑनरेबल एपेक्स कोर्ट की दोनों नजीरें हैं 2022 और 2015, इन सब को मद्देनजर रख करके एक इफेक्टिव एफर्ट हो सकता है कि लोक अदालत के माध्यम से इसका निस्तारण करें। और यद्यपि हो सकता है रिस्पांस हम लोगों को मात्र 10%, 5% मिले, बट आई एम श्योर दैट विद पैसेज ऑफ टाइम व्हेन द मैसेज पर्कुलेट्स इन द सोसाइटी, कुछ ना कुछ इसका रिजल्ट अवश्य निकलेगा। दिस इज व्हाट एट द आउटसेट। एंड नाउ आई थिंक आई विल रिक्वेस्ट समीर जी टू टेक ओवर। कुछ आप अपने व्यूज एक्सप्रेस कर दीजिए एंड देन वी विल रिक्वेस्ट एवरीबॉडी फॉर अ क्वेश्चन आंसर एंड इंटरैक्टिव सेशन। और मैं इस ऑगस्ट गैदरिंग से ये भी कहूंगा कि आप लोग इतने वेल एक्सपीरियंस्ड हैं, हम लोग को भी आप एजुकेट करिए। अगर कहीं कुछ सोल्यूशन है तो आई एम श्योर दैट ऑल ऑफ अस, अगर आप कोई इफेक्टिव सोल्यूशन देते हैं, आपका कोई अच्छा सजेशन है, तो आज हम लोग 700-800 लोगों की तादाद में सब लोग बैठे हुए हैं। आई एम श्योर दैट ऑल ऑफ अस विल गेन विद दिस एक्सपीरियंस। थैंक यू सो मच।